Hi and hello to Dr. Hakima and all my friends. Today we are going to present about the group assignment mini scale project, case study 1, validity of Shariah contract, a case study of Amir and Bilal valid contract in Islamic law. Okay, firstly we would like to introduce ourselves. I am Kuganegan Sarau and my friend is Pravina Nageswar Rao. Introduction for this case study. A Sharia contract known as Akad is valid in Islam if it includes offer and acceptance, also known as ijab and kabul. Capable parties, a lawful item, and agreed payment known as taman. It doesn't need to be written or formal. In real life, many Islamic contracts like Murabaha, Bay al-Islam, and Takaful starts with verbal or online agreement and are still valid. In Amir and Bilal's case, they agreed to buy 500 kg of dates. But Amir later said the contract wasn't valid because it wasn't written. This study will explore if such a deal is valid under Sharia law. We need to have a proper understanding of Sharia contract legal principles. There are 5 principles. Firstly, Akad. Akad means contract of an agreement, binding agreement between 2 or more people to do something like buying, selling, renting, or partnering in business. In this case, the Akad, which means contract, was formed when both parties agrees to purchase 500 kgs of dates. The second principle is ijab and kabul. Ijab is the proposal of offer made by one party and kabul is the acceptance of that offer by the other party. From this case, ijab and kabul, acceptance expressed verbally or shown through conduct, are valid forms of agreement. The third principle is the Aqdain. The Aqdain are the 2 individuals or groups who are entering into an agreement and have legal capacity. The condition of Aqdain is met, assuming Amir and Bilal are adults and of sound mind, making them eligible to enter into the contract. The fourth principle is Mahal al-Akad. In Islamic law, every contract must be about something that is lawful, halal, and clear. From the case highlight that Mahal al-Akad subject matters. Example, 500 kgs of that is lawful, which is halal, clearly defined, measurable, and deliverable, fulfilling the Sharia requirement. And the final principle is taman. Taman means the price or payment in contract, especially in a sale, under Islamic law. This case highlights that in a sale, it is usually understood to involve payment, such as money and barter. If a price was agreed upon or followed local custom, this requirement is also satisfied. That's all from me, and I'll pass it to my friend Pravina to continue the presentation. Thank you.
Thank you, Kuga. Good evening, doctor and my dear friends. I'm Pravina here. Today I would like to present the next one. I will continue with the next slide, which is supporting evidence. Okay, first of all, I am going to explain about the foundation of the Sharia contract law. Okay, it's actually in this, they have rooted in the Quran and also Sunnah. It emphasizes honoring the commitments rather than a formal procedure. Okay, number 2 is the Quranic evidence. Okay, in this Quranic evidence, they have highlighted is Surah Al-Ma'idah 5.1. Okay, they have a belief that fulfill all the agreements based on the Al-Uqud. Okay, next, in this Quranic evidence, they have highlighted that the duty to honor contract once they have agreed. In this Quranic evidence, they actually stated that they are not actually not required written documentation or formal meeting. The third supporting evidence will be hadith evidence, which is focusing on the Sunan Abu Dawud. In this hadith evidence, it is a duty, especially for the Muslims, to fulfill their commitments, which is involve making the unlawful things to become a lawful. Okay, in this hadith evidence, actually validates the contract based on the mutual consent, which is focusing on the ijab and also kabul. And also they have a binding if the contract in this hadith evidence they stated that contains no prohibited elements. Next, I would like to continue with the fourth point is the fourth supporting evidence, which is called as view of classical scholar. From the Imam Abu Hanifa stated that verbal contracts are actually valid if the terms are clear and both parties are competent. From the Imam Malik and Imam Shafi stated that spoken agreement actually are acceptable with the mutual consent and must have a clear terms. Number 5 is the modern Islamic financial practices. There are two. One is for murabaha, another one is takaful. For the murabaha, another name we call as Islamic cost plus sale. In here, they have stated that verbal agreement often occurs before the documentation. For the takaful, which is called as Islamic insurance, they stated that the client commonly give online or verbal consent first. From these 5 supporting elements, they actually are applicable to the Amir and Bilal case, which is if there is mutual consent, which is called as ijab and kabul. Second is permissible and clear subject matter. Third point is legally capable parties. And the fourth point will be if the agreement is valid under Sharia, even without a written document or formal session. Next, I would like to present regarding the critical analysis and evaluation. First point will be from the Sharia perspective, Amir claim shows a misunderstanding of the Islamic contract law. And the second point will be while there is a written contract which are not required under Sharia, but they are still strongly recommended as the legal proof in the case of the dispute. The third point will be as long as there is a key element are presented like ijab, we call as offer, kabul, which is acceptance, capable parties, a lawful item, which is called as a market al-aya, and agreed consideration, which is the contract is valid even though it's a verbal or informal. Next will be without having any record, it actually become harder to prove that what was agreed. Okay, and then the next point will be if all the thing are fulfilled, Amir are actually trying to cancel the agreement without the valid Sharia reason, which is considered like a betrayal of the trust. The next point will be this could be harm Bilal, which is can we go against the principle which is called as no harm should be caused or written. This case actually shows that even if a contract is valid in Islam, good documentation and transparency is actually very important to protect both sides and need to be ensured there is a fairness in the business. As the conclusion, under Sharia law, a contract which is akid is actually valid even without a written document or formal meeting, as long as there is a key elements are presented, offer and also have a acceptance, which is ijab and kabul, mutual agreement, capable parties, a lawful item like market al-aya, and agreed consideration, which is called as taman. Sharia actually values the intent, niyyah, and also the understanding more than the formality. while the Quran encourages writing contract to avoid the risk from happening the dispute, it is actually not required. Scholars like Imam Shafi and Imam Malik, they have accepted verbal contract and a modern Islamic finance, which is until now there is an application in this modern Islamic finance. So Amir and Bilal are clearly agreed and their contract is actually valid, showing that Sharia supports fairness and flexibility in their business dealings. These are the references that we have get through from the Google Scholar, which we have used for our case study analysis. That's all from us. Thank you.